My name's Ari Melber. I'm a chief legal correspondent for MSNBC and an attorney and a writer, and it's an honor to be here with ACS and with all of you. We have so many professionals and experts here, so this should certainly be an enlightening discussion and an honor to be with this panel. Rather than doing any kind of big opening statement or setup for it, what we are going to do is ask Judge Gertner to begin us off on some of these issues, partly based on an article that she wrote. So all I'm going to do really right now is give you brief introductions of our panelists and then hand it over to the judge. Judge Gertner is going to highlight some of the due process issues that she has written about in Title IX investigations. This is based, for those interested, in an American Prospect article, Sex, Lies, and Justice, and is an issue that's gotten news well beyond Harvard's campus as part of a group of Harvard law professors' written responses and analysis of some of the new policies in that arena. And she is a retired judge and Harvard law professor. Did I get all that?
You got everything.
Fatima Goss-Graves works on focusing on ensuring women's equality, including in specifically higher education, and she is going to speak to us about Title IX's importance for women's equality, among other issues. Our government representative, so most of the aggressive questioning and disappointment with the state of America writ large should go to him, is Principal Deputy Assistant Secretary Seth Gallanter. And he is here to speak specifically to what is going on within the Obama administration and education, looking at Title IX investigatory procedures that are encouraged by the department, with a specific attention to what the Office of Civil Rights is concerned about in that arena. And I think it's fair to say there's also some interplay between the standards they're trying to set or encourage and then what individual schools are doing, which of course they're not necessarily responsible for, but that back and forth has also been an important area and an area where there's been some debate. Alexandra Brodsky wrote a piece called Fair Process, Not Criminal Process, highlighting the differences between these Title IX disciplinary hearings and criminal investigations. And she, to some degree, although we'll let her explain, challenges some of the assumption or premise that the criminal context is the only, shall we say, legitimate baseline to judge how schools deal with these administratively. And Meredith Raimondo is going to speak specifically to Oberlin College's Title IX procedures, which are cited by some, including Judge Gertner, as a good model that address some of these things. The reason why I'm doing these introductions more topically than professionally is you can see there's a great deal of nuance to this. This is not a pro versus con type debate, and you can put whatever you want after pro-justice, pro-equality, pro-women. It is not that kind of debate. There is a lot more to it, as you can imagine, and the folks here, I think, are debating this, having written about it, and now going to help us discuss some of it in the good faith spirit that there's a lot that we can try to do better and get right, without assuming that anyone is not looking for justice or not looking for better, safer campuses. Campuses, I think we could say, with fewer crime scenes. And yet there is a lot of work to be done within and beyond the legal community. With that, I will turn it over to the judge to set us up for today.
Sure, thank you. Can anyone see? The problem of being short with a big microphone is that I can barely see all of you, and I feel a little bit like Lily Tomlin. But I will persist. I have a big mouth, so I guess it doesn't matter that I'm short. The piece I wrote in American Prospect really came, perhaps this is an odd thing to say to an audience, it came from my heart in that I describe that I am someone who has been on both sides of the issue of sexual assault, not because I was a judge and I was supposed to be on both sides of everything, but because of my life's work. So I had been and am a feminist, did civil cases on behalf of women who had accused psychiatrists and doctors of sexual assault, or companies that inadequately protected them, and had been an activist for changes in the very sort of retrograde rape laws that I grew up with in the 1980s. But I was also a criminal defense lawyer. And as a criminal defense lawyer, I saw the impact of unjust procedures, of unfair accusations, of imprisonment, of disproportionate responses to accusations of crime. I'd seen that throughout my career. The piece begins with a case that I describe as Paul's case, which is I had never represented a man accused of rape. I refused. I didn't want to use my legitimacy as a feminist to represent a man accused of rape. So when this referral came in from a friend of a friend, I interviewed the man and then I passed it on. It was a very, very troubling case. Young man at a local college, his first sexual encounter. The woman's accusation of rape came 10 or so months later. In between, she had invited him to her parents' house for a meal for the weekend. I won't go into details, but in short, sort of numbers of details which are either consistent with a traumatized rape victim, to be sure, or someone who wasn't telling the truth. I believed him to be candidly innocent. And, but I was true to my view, and I wasn't going to represent him because I really didn't want to cross-examine a woman, and I was a great cross-examiner, and I just didn't want to be in that position. We argued with the government not to charge. We argued with he appeared before the grand jury. The grand jurors literally, we later found out, said we didn't think he was guilty, but we decided to vote for an indictment because we figured he'd be acquitted at trial. He went before a judge for various reasons. The judge likewise talked about the weaknesses in the case and then convicted him. The case was appealed, and at that point I came alive, and we got the conviction reversed. But it was troubling about the amount of work it took, the movement at that. This was one of the first date rape cases, the amount of work it took to move that ship around. And that certainly colored my view of the issue. So when a year ago Harvard changed its sexual assault policies, I was troubled, and I joined the group of 28, being concerned about whether or not there had been an overreaction. And indeed, I might say as a footnote, Harvard's policies were not approved by the Department of Education. So to some degree, this describes concerns about due process and whether what going too far means. Harvard created an entirely administrative process. The Title IX investigator was the one who did the investigation. The time limits were short for those who were accused, but there were no statute of limitations on behalf of the accusers. There were no lawyers involved. There were no hearings. It was an internal investigation with findings of fact that were virtually bulletproof on appeal. The appeal was to the Title IX administrator. I won't go into detail. I think the nuances are better to read about than to say, but suffice it to say that every concept of fair process that we understood was absent here. There were no lawyers, although the accuser had advisors, the accused did not. There was no hearing, although Alexandra will point out a criminal process hearing with confrontation is not necessarily the only way to get at truth, and I completely agree. But there was simply no opportunity to test the accuser's statements at all in any setting that bore any relationship to what we understood, even if it was questioning by someone other than the accused lawyers, even if it was questioning on written questions, even if it was outside, through video. But there was simply this was a completely internal administrative proceeding. So there was no hearing, no lawyers, no opportunity to deal with witnesses at all, and time limits which were so short as to be absurd. The procedures did adopt what the DOE plainly required, which was a preponderance standard. And as I write, a preponderance standard, there may be many who will disagree with it. I understood that the reason for it was that the civil cases are a preponderance standard, criminal cases are beyond a reasonable doubt. But it was one thing to go to a preponderance standard in a civil litigation context with discovery, lawyers, hearings, and trials, and to go to a preponderance standard in a completely administrative proceeding. That was troubling. I won't go into more detail. I know that I don't want to take any time of the rest of the panel, but suffice it to say, my concerns were from the perspective of a feminist, because I worried that an illegitimate process would, in fact, with one or two celebrated cases of arguable false accusations, would turn the clock back. And that was a clock I knew too well. So I want to close on one point on this, which is one of the advantages of being old. Not very old, but old. Somewhat old. Older. Is that you actually see the trends of the past umpty-ump years. And social change doesn't happen overnight. And my concern, as I expressed in this article, was that an illegitimate process, or a process that is perceived as illegitimate, quite apart from whether it is illegitimate, will give fuel to those who believe that there is no substance to these concerns, will give fuel to those who believe that women, as they did 20 years ago, that there are lots of false accusations, which I don't believe, and that it really is in a feminist's interest to make sure that these processes are fair. And that's what I wrote about.
So Judge Gertner and I were joking earlier that we've done a couple of these conversations like this, and each time we're sort of set up to argue with each other, and each time we come to a little closer to the point that we now, I think, mostly agree on a lot of these points. So I'm sorry that I can't get up here and
Yell at me.
Yell and make this really exciting. I guess I want to offer some good news, because I think this is often a gloom and doom conversation, because we're talking about rape. We're talking about students who are losing out on the opportunity to learn, whether or not that's because they've been the victim of gender violence or because they are removed from campus for disciplinary violations. But I think that this isn't as tricky as a problem as we are making it out to be. So undoubtedly, we have a lot of really hard questions to answer, because while courts have long recognized that gender violence on campus falls under Title IX's mandate for schools to take action to stop gender discrimination and to make sure that all students can learn on campus regardless of gender, schools have only kind of started taking it seriously in the last couple of years, and I think that that's because of student activism. I think that that's because of the Office for Civil Rights stepping up its game and starting to hold schools accountable. And that means that we've got some, unfortunately, trial and error to do. We need to look, figure out what models are working on campus for students, for the campus community at large. But these questions aren't quite as novel as we make them out to be, because believe it or not, people get kicked out of school for reasons other than rape. Schools have long been in the business of looking at violations of their school code, investigating, figuring out if the student was responsible, and then recommending a disciplinary action for that. And that's students who participate in other forms of discrimination against their students, so violence based on race, disability discrimination, and also just students who punch their roommates in the face, students who deal drugs out of their dorms. And schools have figured out how to handle that mostly. So for that reason, I think it's really important that we avoid talking about gender violence on campus as, no offense to ACS, sex, lies, and justice on campus, but instead as a question of student discipline. And that allows both for us to avoid the harmful effects of this kind of rape exceptionalism for victims, and there's a long feminist critique of the sort of additional barriers that we put in place for rape victims who come forward, higher corroboration requirements, shorter periods in which they can report, both in the criminal justice system and on campus. But I think it also allows us to benefit from schools' experience of disciplining students for centuries. When we can say, question, what should a hearing look like on campus? Well, let's see how schools have been doing this for a really long time. Let's see if there are particular reasons why that system might not work for gender violence accusations, but maybe they will. And I think the other piece of good news then, and this is something that Judge Gertner mentioned, this is really not a zero-sum game. This is not do we care about the rights of accused students, or do we care about the rights of alleged victims? Because as Judge Gertner said, we need community buy-in to these procedures. We need people to accept that the school is handling these questions in a fair and equitable way, and that, one, make sure that we're actually getting the right people, but also make sure that these complaints don't end up in endless appeals, in litigation every single time, drawing it out. I also think that if we look at the complaints that were in the lawsuits that we're seeing from students who have accused others of violence and students who've been accused of violence, they're asking for a lot of the same things. They're asking for fair and impartial investigators and decision makers. They're asking to know what's going on with their case. What's the current status? What rights do they have? They're asking for support from someone who knows how the law works. And so I think that rather than imagining this as, are we going to put a pebble on which side of the scale, there are a lot of sort of solutions that help everyone here. And I think it's also really important that we stop talking about Title IX, and particularly guidance from the Office for Civil Rights, as a threat to due process here. So this is probably old news for a lot of you here, but sort of like quick due process on campus primer. Only public universities have real due process requirements. Those are incredibly thin. Courts have very purposefully sort of abdicated any kind of judgment here to schools. They have to offer, and this is a quote, some kind of notice and some kind of hearings. That's not enough. I think that we can all agree that we are here because we care about students' opportunity to learn, again, whether that's helping victims to make sure that gender violence doesn't stay in the way of them staying in school, or if it's making sure that people aren't unjustly removed from campus. But because the law has such a low floor for what schools have to do, and it doesn't even apply to all schools, from all of my research, from what I've seen, OCR's guidance for schools handling gender violence accusations are the most robust protections we have for accused students in federal law or policy today. And that means that rather than taking the conversation about gender violence as a threat to fair process, I think we should take it as an opportunity to talk about what should we offer students accused of all forms of student conduct or student misconduct, from cheating to punching someone in the nose to sexual violence. And I'm excited about having that conversation with this crew.
Fatima, why don't you give us your take here?
Sure, and I have to say that I really agree with a lot of what Judge Gertner said as well, but I thought, it's useful, I think, for me to take a step back to think about the purpose of Title IX and what led to this guidance and the requirements that we're talking about. Title IX's ban on sex discrimination in education, the now 40-year-old ban, came about at a time where you saw lots of institutions either restricting the numbers of women who could attend their schools at all, or if they were attending, how it is they participated at all in their educational programs, which courses they could take. So really, when we think about Title IX, core to it is access fully to your educational environment. And when you fast forward to when the Supreme Court considered and addressed requirements to address harassment in school, again, core to that was around, is someone able to fully access their educational environment? And the Supreme Court made clear that schools failing to address harassment, either by peers or faculty-student harassment, interfered with that core right. And so if you think about who has access to an educational program, a fair process is really core to that. And what we were seeing for many years is that because there wasn't a fair process, that you had students who reported assault just leave. and maybe they left for a short term, or maybe they left indefinitely. And there are tremendous costs to that. And I think about, one of the National Women's Law Center's clients who was a student at, an elite STEM institution. And, it was both the harassment she faced and then what happened after she reported, which resulted in additional harassment because there wasn't a fair process in place, and leaving her institution, which she felt she needed to do, and then figuring out where else to go. It meant that she was no longer really able to be in a similar environment. Alexandra also raised what I think is an important point, and that is around the additional hurdles that have historically been put in place and are currently put in place by some schools for students who report rape. And we have a current case that's pending where if you think about what happens if those rules go too far, where a school basically had a rule was that there had to be a third party to witness harassment to really know what to do. Otherwise, it's he said, she said. And the way that translated for our middle school client was that when she reported she was being harassed, a teacher's assistant at the school cooked up an idea that, okay, well, let's sort of do this sting operation idea where he's been asking you to go to the bathroom to have sex. Why don't you go there and go to the bathroom, and then we'll catch him in the act. Well, to fast forward to a terrible long story short, they bumbled that. Our client was raped. They did not get there anywhere near in time. And this was an idea cooked up by a teacher at the school with approval of assistant principal, but cooked up by a teacher of the school. And that's very much steeped in the idea of, well, you have to corroborate these things. There has to be an extra thing for us to believe. So just sort of closing out, I think where we are now that will be a good thing is that the deep attention that schools are putting on this in terms of response and having people who are trained will result in processes that are both fairer for all and that actually go to achieve Title IX's promise around equality and access.
So let me bring in Seth then as the current federal policymaker here. What in these policies that the administration is putting forward is different? In other words, I don't think we have time for the full overview, but what are the things that were not being done that you think these policies can help fix?
I want to give the full overview. No, but
You think you're in control, you're going to.
But I do want to start by saying I think, again, I agree with much of what's been said here. So this is not the conflict panel so much as the how can we get to the right place in the right way. I mean, this administration has done a lot and been a positive force both for preventing sexual violence and addressing it, but also for promoting due process on campus. And it's interesting because under, now Vice President Biden's Violence Against Women Act in 2004, we've had grants about campus safety grants focusing on law enforcement and public health issues for 20, 30 years now. And now we've added, in this administration, a civil rights focus as well. But they're all really trying to get at the same thing, which is the notion, as Fatima said, that women and men have to be equal citizens on a campus, they have to feel equally safe, and they have to be respected equally when they invoke the processes that exist to complain about the conduct of their fellow students. And here, our guidance in 2011 and our follow-up guidance in 2014 and Congress's actions in the Clery Act, which is another federal law that governs higher education and touches on sexual violence, domestic violence, and stalking. All those guidances and laws and regulations together have really spurred not only innovation, but real due process protections for both complainants and those who are accused. And that extends from what our regulation calls prompt and equitable procedures, which means that things can't drag on too long, that people have to be kept informed about what's going on, and that if you give a right or privilege to one party, you have to give it to the other party in these complaint processes, to the Clery Act, which now guarantees some form of right to an attorney to attend and participate, advisors along the way. Those combined have really, I think, encouraged public and private institutions to look and revisit their systems. The White House has proposed a bunch of questions, checklists, what schools should consider, and then every school is doing it slightly differently. I think we're going to hear, Harvard had one model that they're proposing that has not been approved by the Office for Civil Rights, which is currently investigating them. Oberlin has another, which is not under investigation right now. But I say right now because we are spurred by complaints. We don't pick where we go. But I would also just add that I think one flashpoint has been the preponderance of the evidence. In 2011, we said that was a necessity under Title IX, and we said it for a couple reasons. First, there were some schools that,
just to clarify, a necessity as opposed to?
As opposed to some schools had clear and convincing evidence, some schools had beyond a reasonable doubt, some schools had a standard that sounded like one of those, significant evidence, substantial evidence. There were two surveys that were done before our 2011 guidance showed that over 80% of schools, higher education institutions, were using the preponderance of the evidence standards for sexual violence. But what we did find was that some schools used a higher standard for sexual violence and sexual harassment complaints than other kinds of unlawful conduct complaints.
And just to stick on that, and I give you a harder time because you're here from the government, are you saying, though, that in the administration's view, the key there is parity, that it's fair within what the other standards are for that school's procedure, or that it should be what is essentially that lower standard, period?
Both. I think what we're saying is when we came to the situation, we saw 80% of schools were using a preponderance standard for everything. Some schools were using preponderance of most schools were using preponderance standard for almost everything, but not for sexual violence. We add to that two other components. One, this is not a criminal proceeding. This is not a deprivation of liberty in the sense of the government taking away your right to move freely. And so in those circumstances, preponderance of the evidence is the default standard. And think about it in this way as well. In the employment context, where there's also sexual harassment, would we be comfortable with an employer saying, oh, I got a complaint that you sexually harassed your coworker, I'm going to apply a clear and convincing evidence standard. So I think you probably did sexually harass your coworker, but because I'm not convinced to a clear and convincing standard, I'm not going to do anything about it. So again, the link between the safe hostile environments that we prohibit under Title VII and those that we prohibit under Title IX, there was a dissonance there that we thought was appropriate to resolve by saying, you have to figure out what happened to the best of your ability, and that means what more likely than not happened.
So I'm going to cut in there and bring Meredith in because we're well past halfway of our time. We want to get to questions, and I haven't gotten to everyone yet.
All right, but let me just
quickly.
Yes, one last thought, which is we did propose a preponderance, we did propose some frameworks, but schools themselves have used that successfully and built around that frameworks that both provide impartiality and provide the appearance of justice.
Hi, everybody. So I enter this conversation as I think the only person at the table who is not a lawyer or on her way to becoming one. And so I guess what I want to offer is a request to all of you who are lawyers, which is to say for those of us who are practitioners on our campuses, what we are looking for from those of you who do legal work is allies and supporters in the educational process. All students are our students, regardless of what role they may play in this. And for me, the question and the goal of these processes has to start with this. For a student who comes forward to make a report, a safe, supportive space for someone to ask, what are the harms that you experienced and how can we address them so you can continue your education? And for the student who is accused, the question is also important and needs to be met, I think, equally with respect and dignity. But my question for that student is, what, if anything, in your conduct are you willing to be accountable for, and how can you be responsible for the harm you've done to others if, in fact, that was the result of your conduct? Hearings are a tool or a technique for answering those big questions. And I think one of the frustrations in the process, it's really important to me that students have access to legal advice, particularly if they are navigating simultaneous challenges or potentially simultaneous challenges in the criminal justice system and on college campuses. But so often on our campuses today, lawyers are not functioning as educators in these processes and are not allies to our educational goals. When they are, the results are fabulous and I think better for all students. And I'd like to really think about what that might look like going forward, because I do have some concerns that the process becomes overly legalized, right? And so that it ends up being this conversation again and again that sort of this is not law and order, which is what honestly people imagine and think, students think when they enter these processes, especially when attorneys are involved. That being said, I think that the other issue is kind of the larger challenge. So to return to the kind of your point, Seth, those of us who are practitioners in the field, I think, are at the point where it's not if OCR comes, it's when, and that's not a bad thing. Higher education, in my view, earned the scrutiny that it's getting, and we ought to think about that as a positive opportunity for us to do better by our students and think about the ways that outside regulatory agencies support us in that agenda rather than seeing this as a thing to be terrified by. We need transparency in our processes as much as possible, and I think that's how we can help students and their families and the many observers who are interested in this conversation understand what fairness looks like. And that's really hard because we also have to maintain privacy about individual cases, and so often people are learning or coming into these conversations because they know some piece of information about some case. Some of you may, for example, have been following the fairly public debate at Northwestern after Laura Kipnis wrote her piece. It's the case, the challenge in doing this work, that you're almost always explaining it to someone who knows less than you do, and you can't tell them all of the pieces of the information. That would be inappropriate. So the answer to that is to be as absolutely clear and transparent about processes as possible and how those processes achieve the ends of fairness and educational access for all students. It's a really hard message when the answer is, what you need to learn from this situation is you can't continue your education here. But that's also an incredibly important opportunity, and I think some of my greatest frustration and how I got into this work initially was in supporting a student who had sexually assaulted another student, had admitted that, and through the process, because it wasn't well designed, ended up moving further and further away from being able to take responsibility for those actions. That's a failure of our educational process that I don't want to see. And so one of the things I've been thinking about in conclusion is, how do we think at this moment, and what I see as one of the challenges in moving forward, how do we think about Title IX in ways that continues to visibilize gender-based harms and the ways in which that has predominantly affected women, while recognizing the intersection of that with other kinds of harms. So what are the spaces, for example, for men to come forward and report gender-based harms? There's very little cultural space, and when our procedures assume that women are the only people who report, we shut that space down even further. How do we think about bias in this process where gender intersects with race, for example, and those kinds of unconscious biases may shape the experiences of accused students navigating multiple identities? I think that's the really interesting and challenging conversation about fairness we need to have moving forward, and feels particularly acute at a time when in the United States we're talking about the failures of the policing and the criminal justice system around race. I think we elevate the Title IX debate by looking at those simultaneous conversations of fairness and really thinking about how our educational systems, educational institutions do offer us space to engage in experimentation about how to better achieve justice in all our processes.
Well, this is a excuse me, a difficult panel to tell jokes on, but I feel like part of what you're saying is just the famous maxim, first kill all the lawyers, and everyone agrees with that except for the people gathered here. We're just not into that Shakespearean solution.
Right.
But Judge, there's a critique here that is broader than even the standards discussion we were having, that is to the sort of over-legalization of the process, although many would argue that is unavoidable if it's going to be a transparent process. But I want to get your response.
Well, I mean, I think first it has to be said, and it has to be said clearly, that getting kicked out of school is a substantial harm, even if it's not prison. So by saying this is not the criminal justice system doesn't mean that it's not nothing. And by saying that due process guarantees only accrue to public institutions doesn't mean that there shouldn't be fairness when one is losing or potentially losing this education. I mean, that has to be said. This is a substantial loss. But the other thing, I don't think we have to be talking about process. Unfortunately, there's no other way to address this. There hasn't been a cadre of lawyers who've been trained in dealing with these cases, and so to some degree, if there are fits and starts, it's because of that. But there's also an implicit discussion here that I want to surface, even though we can't finish it. There is a substantial question as to what the substantive rules are, the substantive rules of conduct. We're not talking about predators for a moment, or sex with someone who's fundamentally unconscious. There is a middle category, and my general concern with that middle category is the problem here of focusing on adjudication as the way of dealing with behavior. If we're going to establish norms of behavior, the worst imaginable way to do that is in confidential proceedings. And that's really what we're talking about. To some degree, all of this is really about creating different norms of sexual behavior than we've had before. And the focus, because it's been Title IX's focus, has been on adjudication, when there's an accusation of misconduct and a confidential proceeding. And then the question is, how do you meaningfully create changes in norms of conduct? I actually want to think about changing the norms in a different setting than, I mean, I actually think that to some degree the Title IX discussion sweeps back into a discussion of parietals, which for those of you who don't remember were when boys and girls couldn't be in the same dormitory together and you had to keep the doors open. To some degree, we're now getting to that discussion only in the context of proceedings which are fraught because someone could be kicked out of school or somebody is not going to be respected. So I do think that the discussion is about substance as well as procedure, although my article is only about procedure. And how do we address that substance? I have a dopey comment to make. Can I make one dopey comment?
Please.
This is a confession. And again, I hope I don't offend anybody. When I was, before I was married, I used to describe that I had a condition called windows. What was windows? Windows was, you slept with someone the night before, you woke up next to him and you wanted to jump out a window. And you wanted to jump out a window not because you were racked with guilt, but because there was no inadequate intimacy in the relationship and you didn't even want to deal with breakfast. You wanted the fastest way out of there. I'm not suggesting that that would be meaningful sexual assault, but it does suggest the ambiguity of the situation, that's all.
I guess I would push back on that.
Oh, no. Oh, no.
So on 2 points. One, I just think factually the cases we are seeing are not women who regret the sex that they had the night before. I mean, I believe that there are women who have sex that they regret. I don't believe that they decide, en masse that they will go through an incredibly arduous process on campus that will distract them from their studies and make them, in many cases, social outcasts. I also want to push back on this idea that Title IX's attempts to foster better sexual environments is paternalistic in some ways. The debate that I've heard on campus amongst sort of feminist generation older than me are, well, if she got into bed with him to do X, Y, and Z, like, what did she think was going to happen? If she consented to X activity, doesn't that kind of come with Y? And I think that that's such a limited view of female sexuality, that it's an on-off switch, that either we are available or we are not available. And so I see actually Title IX creating space for students, including women, to decide where their boundaries are and to have, in some ways Title IX is a much better symbol than it is law, and to have this sort of vision of an equitable campus environment that they can point to say, I get to decide where you touch me.
I agree with what you said, Alex, except I would say that it is also a really great law in that it has prompted sweeping changes, not because the law was new, but because there was a feeling that there was someone who was serious about enforcing it. The second thing that I want to raise is, I think everyone on this panel would agree that there is real substantial harm in being kicked out of school. I think the challenge is it's taken a long time to recognize that there is real substantial harm in effectively being kicked out of school if your report of sexual assault isn't properly addressed.
And if I could add to that, I think one of the things we need better data on, and I'm glad to see it starting to come through, is the profound academic impact of any kind of sexual or gender harassment, even when the students remain, and that is almost always the first thing that brings a student to me. I'm struggling in my classes, right? So actually people don't come forward because they're thinking about the person they're reporting, or they're sort of anywhere near the decision about what they want in terms of that person. It's, I'm afraid I'm not going to succeed here, and I'm really struggling and I need assistance. And to me, that's the core issue about educational access that we really need to think about. I guess I have been on colleges' campuses enough to believe in and trust that this generation of students, like probably every generation before them, is exploring the world of sexual ethics in a positive way. And so that's something that's always in a process of change, and that's a good thing. How we then codify our common understandings in policy, or our sort of understandings about what's acceptable and not, is a really important community conversation. And we need to continually have those community conversations and revisit our policies. I think if we somehow accept the idea that harm can only be articulated through, say, state legal codes, and that communities can't see ways to identify harm otherwise, we're actually probably not serving our communities and our students and our faculty and staff well. On our campus, we like to have the compliance as the floor, not the ceiling conversation, and I think that's really important. It tells us what the minimum is, but that doesn't mean that communities can't reach common understandings about behavior and we're better than a university campus to have these hard and messy conversations of the kind Judge Gertner is calling for, about how do we think about what sometimes get termed the gray areas, although I myself am uncomfortable with that language because I think it's used too often to discredit particularly women's experiences of violence.
So implied in this part of the conversation are, it sounds like, two models of adjudication here. One is similar to the sexual harassment professional workplace situation that was discussed earlier, which is this institution, this organization, needs to fix a problem to continue to function as an institution. Within that is legitimacy and respect for individuals and having a process to try to address something, but ultimately to move forward as the institution. And that seems different in a civil procedural model from trying to change the culture, from trying to change the way that particularly these young people whose opinions and experiences are very actively being formed, right, are going forward. And so I guess the question in specifically the Title IX context is, in what ways does this procedure help change that culture and shift that culture? And as for substantive sexual assault law, I mean, as you were referencing earlier, from a feminist critique or just, I would say, non-sexist point of view, most people can see that old laws which acted as if non-consensual sexual assault was the line, but then enforced only if a woman actually could prove she went far beyond that line, physical resistance beyond lack of consent. Well, obviously that space, right, may have been building on a sexist culture that existed, but certainly made it worse. So what in here do you all feel is working on shifting that culture, or what more would need to change?
Well, one thing, as schools are thinking about updating their policies, it should be a community conversation. There are obviously legal boundaries, but they should be engaging their student stakeholder, their faculty, their administrators, and part of that engagement, I think, is a potentially culture-shifting approach, and that's very different from just presenting a policy to your community and expecting buy-in. I think that having more engagement in the front end could help address some of the concerns we hear.
I'm always hesitant to talk too much about punishment because I think that schools are tasked with doing so much more than just, putting people on probation or suspending them or expelling them. They offer academic accommodations, they can offer dorm changes that can be really essential for a survivor continuing his or her education. With that being said, I do think that having real sanctions for misconduct changes the culture. I know when I was an undergrad, there was sort of like a little clump of guys who everyone knew had assaulted a couple of women on campus, and all of them knew that they had been reported to the school, had faced no repercussions, and sort of brought that information back. And I think that students learn from their school taking sexual violence seriously.
Can I say that to some degree we all litigate and make rules by narratives. And the narrative, the narrative which was appropriate to focus on was of women who had been ignored and not supported in their accusations of sexual assault. There's also another narrative which is hitting the press, which is a narrative we also have to pay attention to, which is the narrative in the lawsuits brought by men who claim to be falsely accused, or the narrative of the man who's been adjudicated not to have been responsible, and then the woman is protesting what went on, when it was essentially, arguably at least, a fair process. So that's a narrative you have to pay attention to because it's an important political narrative. The former narrative, the narrative of unredressed assault, I saw at the American Law Institute model penal code discussions when the committee that wanted to change the model penal code on sexual assault, which needed to be changed because it was the old-fashioned force model, suddenly proposed criminal sanctions for a range of sexual misconduct that went far broader than anything that anyone had ever seen. And although Alexandra and I talk about the difference between the civil setting and the criminal setting, it's terribly important to be attentive to when this begins to bleed over into the criminal setting, where imprisonment hangs in the balance and where we do not use the criminal law for social change. So I do think we have to be attentive to the swings in both directions.
And that's a piece I definitely wanted to get to before our questions, and I'll go to starting with Seth, which is how much of the Title IX architecture as it is today exists in this space because of the failings of most local criminal enforcement to these assaults, and how much improvement on that side would address this, or do you see them as always having to operate in tandem? To put that in non-lawyer terms, if someone is picked up on a burglary or an attempted assault or an attempted murder or a rape and removed from campus that night because they're arraigned, that is a very different set of circumstances that go forward that for the school to deal with than if they are the only adjudicative body. Sorry that my real world examples still use the term adjudicative.
I do think there's always going to be a need for these parallel processes. I mean, we do have a very strong critique out there in the world about how the criminal law functions. I think Judge Gertner's example is perhaps a good example of that. I mean, even with to emphasize the probable cause that the police can use to arrest, the probable cause the grand jury uses, the probable cause, the discretion of the prosecutor, the decision of the judge, the reversal on appeal, the decision again of the prosecutor because the student wasn't acquitted, just the conviction reversed to not go forward. Criminal law takes a lot of time. There's a lot of discretion in there, a lot of choices made, whereas and that's in a system like that's working relatively well. We need to have a system that's prompter and that can deal with the real world consequences that are affecting the campus that day, that week, that semester. If we're going to be providing real justice to students who usually are not in a school more than 3 or 4 years. Also, I would add that going back to, I think it was Alexandra's example of the drug dealer, if a police officer picks up a student and finds drugs on him, he gets out on bail, he goes back to school, is the school just supposed to wait until that case is adjudicated to decide, hey, we should figure out whether that kid really is a drug dealer and if he's dealing out of his dorm room, or should they wait a year for a plea bargain or whatever to the criminal justice system ends up meeting out? So I just can't see the two systems. They are both necessary, obviously, for sending the right signals, for adjudicating whether the norms that civil society and the campus society have set have been violated, but they serve very different functions.
The criminal justice system also can't make academic accommodations or change living arrangements or correct whatever ongoing harassment someone who has come forward may face on campus. There's sort of a separate educational need for schools to be involved.
But there's actually a complicated relationship, though. On the one hand, if you're facing charges at school and also facing criminal charges, you can't speak, you can't defend, because if you defend, that will be used when liberty is involved. And the problem is the failure to speak sometimes means that you'll then be convicted, arguably, or you'll be found responsible in the university setting, and there will be consequences to that, even if you're ultimately acquitted. And if you're ultimately acquitted, many of these programs, many of the policies, don't have a way of undoing that finding as a result of what happened in the criminal law. I mean, I agree that there has to be some process on campus, even with respect to things that are also in the criminal justice system, but it is very complicated. And the problem is that the relationship between the two could really result in consequences to someone going to jail. So I think that actually has to be an area that has to be carefully thought out.
I think that that's true, and I think it's really tricky. I apologize for being so repetitive, but that's also true if you are facing simultaneous criminal charges and school charges for dealing drugs out of your dorm room. And I would love to see 28 Harvard law professors write a letter about the criminalization of drugs in Massachusetts.
Sure, I will. As I said, I've retired from the bench. My chances on the Supreme Court are shot. I can say anything.
Well, but I think you're speaking to something that is part of the issue, which is there is a view, and counter as you like, that the shortcomings in the area of criminal enforcement of sexual assault, particularly non-stranger assault, the type of issues that at least are presented as ambiguous by one side and involve two people who know each other, right, is a particular failure of criminal local enforcement that doesn't occur in the war on drugs, which has been, if anything, overly aggressively enforced to the degree that however you come down on whether it's overly done, if you're a school and people are getting picked up for dime bags all the time and put in jail for them, that solves itself, right?
Oh, sure. There are many differences between criminal responses to drugs and sexual violence. I will just say that I think that generally survivors are much less interested in the criminal justice system than everybody else is. One of the big things that student organizers have had to work to resist are these proposed state laws that would require schools to pass on all reports that they get to the criminal justice system. And I get why that sounds like a really good idea, particularly if you're like a 55-year-old legislator who has a 17-year-old daughter. But overwhelmingly, students are saying, I don't really want to call the cops. I don't think that they'll treat me well. I'm watching Ferguson. These are not allies in a fight against justice. And I think that, so I guess I'd sort of resist the idea that there's some kind of hydraulic system here that we're turning to schools because the police aren't handling this appropriately, and instead that we're turning to schools because, as Fatima said, they can offer solutions that the criminal justice system can't.
Because they handle it better, or because the lack of a sort of jail punishment outcome creates more space for people to want to report something?
I think it's a combination. I think that part of it is that people often feel more comfortable going to a dean that they know to say this scary thing happened to me than going to police officer. I think also a lot of the time, and this really does get left out of a conversation that centers on punishment, so often what a survivor first wants is, I have an English paper due Monday, I just got raped, can I have an extra week? Or I share a dorm with my abusive ex, can you move him out or move me out? And those aren't really those don't make for a fun, sexy conversation because they're so mundane, but I think so often that's really what students most need to keep going to class, to keep learning, to stay on track for graduation.
I think I'm going to ask folks to start coming up for questions. You can line up. You know the drill. You can introduce yourself, ask a question.
The entire audience is now lined up.
We are, in the spirit of First Amendment jurisprudence, we are not going to discriminate on content. You are free to ask a question or make a comment or criticism. That's fine. All we are asking on behalf of ACS, as you've heard at other panels, is timing. So try to keep it under a minute, and if it's just a comment that you want to make, we will have the folks respond to that. I think what I'll try to do, depending, is 2 at a time. So 1, 2, and then we'll respond. Please go ahead.
Hi, I'm Kristen Cabral from Virginia. I wish everyone in this room will go see the powerful new film, The Hunting Ground. I just saw it for the first time on Thursday. It tracks this movement. My question is, what do you think of the new California yes means yes law? And also, just a fact I've come across is that there are 400,000 untested rape kits in this country. And that much more of a deterrent to go to police because they're not even going to test the evidence.
Hi, my name is Joanna, and my question is going to focus on the University of Oregon case, and I think it raises some issues we haven't touched on today. So Meredith, you said one of the first questions for you is to the accuser, what can we do to create a safe space for you? Well, in that case, as you hopefully know, there was a sexual assault victim of a gang rape. The 3 perpetrators were expelled. She then sued the university because she was claiming they had prior knowledge of recruiting one of the athletes to campus that he'd been previously accused. When she sued, the university counterclaimed against her and accessed all of her medical records, including her mental health counseling about the rape that she received through campus mental health clinic. The university has defended that under FERPA, saying it's not privileged information under HIPAA. And so my question is, why in my right mind would I ever tell a student to go through a campus process if the university can pierce medical records to defend itself?
Who wants it?
I can tell you that we had enormous conversation about that on campus the day that story broke, and certainly confirmed that counseling records are private. So my understanding from conversation with the head of our counseling center and our council is that when students release counseling records themselves into non-confidential processes, then those may be accessed by the institution. But the student would have the right to decide whether to release counseling records or not. So, I think what we have to do there is be really, we're navigating multiple laws here, right? So there's FERPA, there's HIPAA, there's Title IX, there's Clery, and I think we really have to be very careful to make sure that students are fully informed about the consequences of different choices. So not knowing what that student knew about what, and again, I've read lots of versions about what may be true there and have done this work enough to know that I probably don't know. But I do think that my understanding is there are certainly ways to make sure that students have access to legally protected confidentiality, and we need to make sure we are educating them very fully about how to ensure they can protect that right.
But the question is whether in affirmative litigation, the question is the first is the question of the confidentiality of counseling records in a criminal case, where on the one hand there are Sixth Amendment and Fifth Amendment rights accruing to the defendant, and on the other hand there are the privacy rights of the accuser. That's a different balance than in the college setting. And in the Oregon case, I don't know about the Oregon case, but the question then is not did she expose her counseling records, it sounds like, in an ordinary college proceeding. The question is whether she exposed those records when she affirmatively sued. And that may be a different question. That may be a different question. The affirmative consent issue, I think, is complicated. Maybe there are people on the panel who will weigh in one way or the other. I think that that's a complicated question. The litigator in me says that, in fact, it will just, I hate to put it this way, will move the point of lying. He'll say there was, she'll say there wasn't. I'm not sure it will make an enormous difference. It certainly has made a difference in the discussion. On the one hand, I like the notion that women take responsibility, that women can't hide behind, I got drunk and I wasn't really sure, and women take responsibility for sex. I actually I have the reverse feminist critique of other people. On the other hand, as many have said, sex often doesn't work like that. I think it's a more complicated discussion. Alexandra?
Yeah, let's go Seth and then Alexandra.
All right, I wanted to talk on 2 points that one was raised by Kristen about the rape kits. That is a huge problem. It's not a sign of necessarily disinterest, but also the evolving technology, that what used to be untestable has now become testable, and the administration is trying to push funds through to get law enforcement to test those kits, and that's going to be incredibly valuable for public safety. The other thing that Joanne raised about Oregon, I personally think it is kind of outrageous that the school went and looked through the records without a court supervision. Even in affirmative litigation.
That's an interesting
and
question.
we hope that, there's state laws, federal law is only supposed to be a floor, our FERPA, our HIPAA work, and we are looking into providing, some kind of guidance to schools that are interested in, keeping up with what people's expectations are about the confidentiality of their records.
Because the mental health folks there didn't want to release the records, and the University General Counsel's office pushed them and took them.
It's a very, as Meredith said, it's a very complicated pastiche of state, federal laws, but at the bottom line, there are things that the university chose to do that they didn't have to do.
It is a very aggressive interpretation of what they were permitted to do.
The rape kit example, which I'm sure many people are familiar with, when you look at just the massive number of untested kits, and it is evidence of what is a potentially serious violent crime as alleged, is, I think, as a lawyer and a journalist, one of the most objective indications of how these types of charges, these types of allegations are treated so differently and given the second-class status throughout the country. It is hard to do the thought experiment of thinking of other violent crime evidence that would just be left to linger like this. As chief legal correspondent for MSNBC, I recently interviewed Manhattan DA Cyrus Vance, where they cleared the rape kit backlog, in that vicinity, and then he's using basically money he got from other unrelated criminal settlements for financial crimes, essentially, and put forward a national program to offer that up to any jurisdiction that wants to then settle up their kits. And in the interview, he was saying this is untraditional, and some criticize it because of the nation of using the settlement money that way, but he's doing it very explicitly to say this is what it takes if local governments and politicians won't do it and the feds won't do it. He's trying to nationally do it, which is interesting in and of itself, at least whether you agree with the method or not, the fact that it is so needed. We'll take two more then.
Hi, my name is Samantha. So in college, I was a resident assistant, which means that I was a mandatory reporter for things like sexual assault. Do you think it's helpful or problematic to have peers in the reporting process? And do you think having a uniform training process, perhaps led by the OCR, would be helpful in creating a more fair and just process so that peers know how to handle these incidences? Thank you.
Sorry, when you say in the reporting process, do you mean sitting on disciplinary boards or being mandatory reporters?
Being mandatory reporters as like the front line to bringing an accusation to the university.
So we classify.
I'm sorry, the two rule.
Oh, sorry.
My name is Miriam. I'd like to go to a conference just on the topics being addressed by this panel. I really appreciate Ms. Raimondo being here. I think that it is essential to Judge Gertner's point of addressing substantive issues of consent and agency and what do we mean when we talk about sexual assault, to not just talk about procedural issues, and to have people who are working with these communities I did want to ask you to address not the individual case of Professor Kipnis and the kind of outcry about the retaliation complaint that was made against her for speaking out against what she, I had a lot of friends in academia who were reviled her original essay, but also were very concerned about the retaliation complaint that was filed against her for writing that essay. But I have a lot of friends who are also sexuality educators who are less concerned about the possible infringement on academia and more concerned about how do we really start instituting a lot of change in thought and behavior around consent and agency. And so I'm wondering if Title IX provides the kind of remedial measures, injunctive kind of relief that would allow more sexuality education, not as people taking courses as students to become sexuality educators, but students becoming more conversant in consent and agency.
And let's take one more, because I want to try to get through everyone who's got a comment.
Hi, I'm Misha. My question is a little bit less deep as the ones that have been presented, but Alexandra, you made a point earlier about the title of this talk, and I'm really considering doing a talk similar to this at the University of Iowa, which is where I go, but it needs a better name. I do agree with you on that point. So if there are any suggestions from anybody up there, but particularly you, because I think you maybe have some insight, being a law student and what would bring you to a talk like this one, I saw the name and I was like, okay, well, maybe we can have some discussion based on that. So if you could talk about that.
So I have two thoughts from the questions. The first one around RAs, and I think whether RAs, I'm not going to call them mandatory reporters because I think a lot of times people think that means to the criminal system, but whether RAs are the types of people who have to elevate a report of sexual assault to other people in the university and are responsible employees, I think it's going to depend on what their function typically is. If they typically are the people who are addressing in a dorm crimes that occur in their dorm or rule violations in their dorm, it can't be that they address all rule violations and crimes that occur in their dorm, but not sexual assault. You can't sort of have a system that works like that. You might set up so that your RA is more of a counselor mode or someone who is not seen as a rule enforcer, and so you wouldn't want that same setup. But the second thing around whether Title IX provides for broad remedial measures, I mean, that is the hope in any either court order or even private settlement, that you're going to be addressing not only the individual harm, but thinking through how do you correct the environment going forward. And in most agreements I've seen, forward-looking training and culture shift is typically a part of that.
Yeah, I agree with what you said. I think for me the key is respecting the right of people who are reporting sexual violence to make choices about who knows what and when, while breaking institutional silence. And so the key about RAs for me is we never want a situation where someone thinks they have told the institution and then the institution doesn't respond to their needs. So that's a kind of educational conversation on each campus about what are the options for private conversations, and then how does the institution make sure that information is being appropriately shared so that somebody's needs are met. I do think Title IX is serving right now to push those culture change conversations, and I guess my thought, but maybe Alexander, you have thoughts about this too, is that students have made that happen. It's a generation of student activists who have used Title IX in incredibly innovative ways, and anyone who does this work knows that sort of at the point of a hearing, they're terrible things. They're terrible things for everybody involved, even when you get the best possible outcomes for everybody involved. And so the only good place to be is reducing the number of them that we need, right? And that's where I am so frustrated when people see Title IX as anti-men, or that this kind of movement is anti-men, because not only are we finally at a situation where we can speak about sexual harms done to women, but it also opens the possibility of clarifying that most men in college don't assault people, right? I mean, and that's really important. And the more we denormalize the idea that sexual assault is part of the college experience, that's protective for both men and women. And I apologize for the kind of heteronormative framing of that, although that's been what's most visible. I think that that's where Title IX, to sort of get to the not needing to have adjudications, to get to the harms not occurring, we have to talk about what kinds of education about sexuality is taking place. And for me, that's where affirmative consent is most helpful. We do have an affirmative consent policy on campus, and it's incredibly useful in the prevention work.
Yeah, I think it's so interesting that in some ways there have been critiques of the Janet Halley School that Title IX isn't allowing people to be sexual in the academic environment. And I mean, we can have questions about like how sexual do you need to be in the academic environment? But I think that when we see Title IX as student organizers saying it is important to us to be able to be sexual if we want to, and that shouldn't be such a risk. That we have to choose essentially between our sexual identities and our academic identities, that there's a real sex positive vibe going on there. But speaking of that, just to talk about the title question really quickly, I do think that there's a way in which we really sexualize these conversations. I think we see that from titles that confuse rape and sex. They are very different things. I think we see that from a lot of the pictures that get chosen when journalists write about sexual violence. It's always like a woman in a little tank top, often with some kind of like almost like bondage Wonder Woman thing going on. And I think it's important that without this doesn't always have to be like gloom and doom, some girl crying into her, her pillow, which is the other picture we get. But to avoid in our advertisements sort of titillating people to get their attention, because there are other reasons why people should care about this.
Could I just add really briefly that I think one of the concerns for faculty right now is that it is a very challenging environment around academic freedom. And so what I've experienced is faculty raising concerns about will Title IX contribute to that. But I actually think OCR has been really clear on the academic freedom issues, and we just need to kind of continue to re-articulate the actually already very clear guidance on that question.
And what about Miriam's question about some of the retaliation issues?
Yeah, I mean, it's extremely real for the people who are both working directly with survivors of sexual assault. That's real for people who have spoken out more aggressively. And that retaliation for faculty looks sometimes like not getting tenure, or sometimes being, slowly walked out, or being ostracized entirely. So it is something that we hear about from all over the country.
But it's retaliation. I mean, this case was retaliation for being critical of Title IX in the article in the Chronicle of Higher Education. So it's both sides. It's retaliation for just on both sides of the issues. And I do think that I'm looking around the room at the people who defend people who have been claimed that there was unfair process, men who claim that there's unfair process. And I think we do have to recognize that there have been places like Harvard where there was a swing that went too far. And we have to keep on talking about the swing going too far. And the Kipnis case is a going too far situation. It may be that when there's social change, you oftentimes have swings like that, but we have to be attentive to it.
And Nisha, can I answer your question as well? I mean, I think titles are so important because most people aren't going to do the discussion we're having today, although hopefully some of this permeates, right? But the titles, the frames, the heuristics, if you look at, say, a very different context, for years after 9/11, you had this thing called the Patriot Act, which is almost comical in its overcompensatory name, right? How can you be against the Patriot Act? But it's not a coincidence that the thing that dialed part of it back, at least, part of where the metadata lives, was called the Freedom Act. Right? The people who wanted to stem Section 215 of the Patriot Act didn't worry themselves with, gosh, this name brand, over patriotic bald eagle on my, legislative outline thing is really silly. I think some of them probably felt that way. I've had stabbers on the Hill tell me that on background, but they didn't get caught up in that. They felt, oh, this is what we're doing, fine. We have the Freedom Act, and it's all about free, and so it all becomes, now, not that we aim to think that simplistically, but the frames matter. And so translating that to your question, I mean, I do think a very important thing for campuses is to talk broadly about sexual assault, harassment, unwanted, unconsented conduct, and actions, rather than what you see particularly in the popular press, which is a use of the term rape, which is the most serious offense in this context and a problematic one, at the exclusion of the context of what we're talking about. And that, I think, leads to these conversations where you have, and by the way, it's like young people who may not know better, need to know better, and we have to help teach, but it's like some kid who just got out of high school being like, well, I'm not a rapist, quote unquote, right? And that might be true, and yet that person might also be exhibiting conduct that is criminal, right? And so, as silly or stupid as that sounds, I think broadening that to the degree that is part of the educational process and the enforcement process is really important. So that's one thought on the title from your humble moderator.
Sorry, can I, not just to like keep up our little shtick, can I just comment on the swinging back really quick?
Oh, yeah, to my comment.
Yes, but we have 12 minutes, and I do feel a fidelity to them, but would you want to do it quickly?
We'll have another conference sometime to talk about this.
I just want to say, it's not like rape victims are walking around Harvard and Northwestern right now being like, victory, we have won. Kipnis was also found not responsible for the complaint that was brought against her, and we can question whether the school should have investigated it. But schools can mismanage some cases that go against a historical pattern without this suddenly being this like misandrist wonderland where we've won.
Hi, I'm Ben from Florida. Thank you guys for a great panel, very thoughtful. My question is on, several panelists mentioned that there's a community conversation around changing the substantive rules of what is acceptable and not acceptable sexual behavior, and several panelists kind of left open room for different institutions to experiment on, where that line is. My question is it problematic to have the same conduct be sanctionable at one institution and not the other, so that the definition for assault or rape or inappropriate behavior is different, for example, at Florida than Florida State, or Michigan and Michigan State? And I was wondering if the panelists thought that was problematic and how to grapple with it. Thank you.
Hi, I'm Laura. I'm from Kentucky, so I have a bit of a different perspective. I think my question really is, when you go to the beginning of college, and before you even get to any sort of sexual misconduct, rape, and then the hearings and things like that, before you can even get there, there's student orientation, right? Pretty much every student has had student orientation. And we talk about how not to get raped and how you shouldn't walk alone, shouldn't wear short skirts, things like this, don't drink alone, whatever. Why not also have an affirmative consent talk? This is what consent is. Let's not be rapists, let's also not get raped. Let's make it on both sides of what is consent. Let's have an affirmative consent talk at student orientation before you can even get to what might happen down the road. And I was wondering, what do you feel about that? How do you feel about talking about consent just as if, just as if you talk about being responsible with sex, and this is a little crude, but saying, take a moment for a condom, take a moment for consent. That's kind of how I look at it. So what do you guys think?
Sorry.
Let's do one more.
Hi, my name is Robert, and actually my question's somewhat related to that. We talked a lot about the distinction between the criminal justice system and administrative hearings, but we talked mostly about punishment and adjudication and what happens after the fact. But I feel there's also a really big difference between the two before the fact, in that when students go to a school, they waive some of their rights for as long as they're on campus, and the right to be free from harassment and assault is not one of them, but a lot of the freedom of expression, a lot of the things like that are. And so as far as the accused are concerned, I'm not so much concerned about what happens after the fact, but the fact that they have fair notice that they're on a higher standard while they're in school. And to say that they have done something that is less than assault or less than rape in the criminal world may still mean that they've violated the standards. And if they're aware of the school standards, then maybe being held to the standard is not necessarily a bad thing.
But I was just going to add, and I think Seth mentioned this, that the recent VAWA, the Violence Against Women Act, amended the Clery Act and requires schools to do a range of primary prevention programs and training of their entire campus, essentially. And so I think what happens in orientation may be evolving, because that's a very new law, and what that sort of training and what information is in there. And I would like to see it not just be around consent, but around healthy relationships more broadly, around bystander intervention, and not just how do you make sure you're, not walking alone at night.
If I could just add something, I think that both Ben, Laura, and Robert all raised, which is, there's 7,000 institutions of higher education in this country, from the small barbershops and cosmetics to large state schools to the Oberlins and I don't see it as a problem that the substantive behavior may differ from campus to campus. One of the reasons, particularly students in your position, get to choose among selective institutions is because they have different communities, they have different values. Now, hopefully they all share some similar values to the states, to the criminal law, but they may all be different in very unique ways. And so I think Robert's point in particular about knowing the rules and with your eyes open, embracing them as a member of that community is incredibly important. And it's also why I think from our perspective in the federal government, we really mean there is no one-size-fits-all solution. What's going to work and what you want to work on your community may not work for a different school in a different place in a different state with a different set of students. So we can't, I think one of the earlier questions was, can OCR do uniform training of RAs across the country? No, because we don't know just the difference between counseling RAs and law enforcement RAs, but we don't know your school. You know your school. And when we get involved, when there is a failure and the hearing process isn't working, it is because the system didn't work correctly up front through the prevention, through the norms, through the training should be going on, which we don't prescribe, we can just encourage, and we only see it when something hasn't worked. I would also just add a personal note that I'm not sure I agree with Robert that you give up your freedom of expression when you're going to a school. Now, maybe you enroll in a school that's told you up front, we don't tolerate dissent, and we're a private school, so we don't have to. I don't know if VMI might be an example of that, and maybe that's good for some people, but I do think, again, for many schools, you go to college in part to have the freedom to express, but understanding that other people can disagree, other people may be hurt, and that there's a cost to process. When we put in all this process, we let people complain, we advertise. You can complain if you feel there's been a law violation. The person who is the recipient of your complaint is going to be burdened by that process, but it's part of the cost of having complaint systems in place. As someone in the federal government, and I think most of the people here, and many in the audience have been in the federal government, if you're a manager in the federal government for more than 5 years, you're going to be accused of a labor violation of some kind. Not because you did anything wrong, it's just the nature of the process. And it is part of the cost of living in a society that recognizes rights and tries to provide remedies, is that there's going to be process costs.
An Obama appointee complaining about overregulation. You heard it here at ACS weekend.
Defending the cost of hearing, of giving people a chance to have their grievance heard.
Let the record reflect I was joking. No one from the Washington Post should quote you as such. My comments should be printed only in italics. Final questions.
Okay, so my name is Bilal Siddiqui, and before the tribunal is over, when someone's accused of a sexual assault, I'm wondering how are these campuses also trying to protect the privacy of both the accuser and the accused before any judgment has been finally made? Because if someone is being accused enough, that does actually damage the reputation, especially in the world where social media is everywhere. So I'm wondering, how are these campuses and how are these programs having due process at the same time defending the privacy before the decision is made?
Hi, thank you. My name is Nicole Aronson, and God, I wish I could ask all my questions, but I'll keep it short. To piggyback off that, I do think that there's a problem in when Alexandra was discussing the group of students at, I think you said your undergrad. There's a similar stigma to someone who has alleged, I don't like just using the rape analogy, but some sort of sexual assault, and then there's a negative finding. Now, I'm not saying just because they think they're right, there needs to be a positive finding. I mean, that depends on the investigation, but I think it goes both ways, especially when we're kind of like with the Rolling Stone article, people are sort of hesitant to believe women. I personally feel like people have always been hesitant to believe women in this instance. The sum of my question is more if whether, I think Seth, you might be best equipped to answer this, but I'm curious on opinions, if it's problematic and if you have any guidance to offer for schools. I get that schools are different, they're gonna have diverging policies. However, at least at my law school, I have been told that they haven't been given enough guidance. This is a floor, not a ceiling. Okay. But so they don't know, it doesn't seem like they know how exactly to enforce it. And I realize there might not be a specific book that says this is what you do because situations can run the gamut. But to that extent, I feel like they are very inadequately enforcing regulations of Title IX and of the Clery Act. One example of this is, what is the process supposed to be for them to actually do an investigation? I mean, is there any set standard for that? You say you pick the school, and so therefore you're kind of submitting to whatever their regulations are. Well, if their regulations imply that, I feel like they interpret their own regulations. You can't say, no, you mean to do this. So when they say, no, we followed it, what else is, what's left to say, no, that was inadequate, and I don't think my rights are being supported. I don't know. I don't need more examples. I mean, hopefully that makes sense.
My name's Kirsten, and I'm about to go into the military, so I have kind of that's coming up, a lot of sexual assault stuff, I'm sure. And my question is prevention, which I feel like is kind of like alcohol. Like alcohol and how, oh, is it not loud? How to deal with alcohol on campus, basically, in the preventive context, which, I know when it gets brought up, a lot of times victim blaming is the response to that, which I just feel like is probably not very helpful. And just, I guess to give context to that, one of the things I found clicking around on the JAG website was a training program they did where they put their enlisted through a mock trial, where the facts were that the girl was blackout drunk, and the guy said she was super consensual, and you have various eyewitnesses describing the night. And the response from the mock jurists, who are all, young enlisted out of high school, was, this made this issue come alive to me more than any other training, and we get a lot of training on sexual assault, because I had to be a fact finder, and I don't know what the facts are necessarily. So I just throw that out there as a preventative training issue.
So thank you for that question and all of the questions, which have been very enlightening and useful. What we're going to do now is just, go down the panel one last time, speak to whatever the final three and anything else. We have about 90 seconds, so we'll run slightly long, but let's do just those brief final responses, starting with you, Judge.
Okay. Prevention is critical. I think I mentioned that I actually think that that's the focus. I think there's something troubling about trying to come up with rules of conduct in the context of adjudicatory proceedings that are confidential. I was on the administrative board at Harvard, and there was no context for you can train someone up the wazoo, and you still don't have a sense of what to do in the situations, to use Alexandra's word, that are in the middle. So I do think that the conversation at the beginning is the critical conversation. I do think we have to do something about alcohol. We do have to do something about, arguably, fraternities and sports figures that are protected, et cetera. We do have to do institutional stuff. I also think this conversation didn't adequately, I think, take into account that the atmosphere in many campuses has changed dramatically. That the fair preponderance standard and the publicity that has been attached to this has actually, in my view, as I said, being on the ad board at Harvard, led to a presumption in favor of the woman. You may think that's right or wrong, but that really has led to a presumption in favor of the woman, and that the threats to lose funding lead administrators to err on the side, and today, not years ago, but today, to err on the side of the woman making the accusation, because if they turn her down, there's a risk for their funding, and the risk of press. More often than not, if they rule for the man, there won't be that kind of risk. So I think you do have to take into account that there has been a swing. It may be an appropriate swing. It may be the way social movements happen. But there has been a swing, and we have to be attentive to that.
I guess I just want to say two things. I think that the first is that I do think that we're going to get to a place where there will be a deeper understanding of what really makes a process that is fair, and that some of it will involve dealing with things like confidentiality, which is in everyone's interest, and some of it will involve ensuring that there's no stigma that attaches for the broader community to any of the parties that are involved. The second thing is on the preponderance of evidence standard. I think that standard is absolutely tied to having a fair process. It's not a standard that works if there's a process that seems unfair. And so I think even a perception of an unfair process puts what I think is an important standard at risk.
I agree with the judge that there has been a change on a lot of college campuses. I think we tend to all agree that it's been a positive change. I think to the extent there's a perception that the Department of Education only cares about the complainant, that's not true. We accept complaints from men, from those who are accused, saying the process has not been prompt and equitable, that I have been deprived of the rights that the accuser has been given. So we are in the business of creating a fair and equitable process, not a process that's for fair and equitable for one side. I would also just add to a lot of the last comments, I think there's a bunch of pieces here. One, as the judge has said, there's the need to have a shared understanding of what the rule is that we're trying to enforce. That has to come not at the adjudicatory process, but through these conversations leading to some written document or something that can give people notice. And then we have to rely, we lawyers, and we have to rely on other skill sets, the public health skill set, the educator skill set, to figure out how to teach people what those rules are in ways that are accessible to them and get them to come to meetings, the whole title thing. So we have to have marketing, we have to have educators to come together. The lawyer's role in all this, my role from the Department of Education, is the floor of Title IX, the process floor at the end of when things haven't worked out well. But there's a lot of flexibility that schools have under Clery, under Title IX, to have those initial conversations, to have their lawyers write it up in legalese, and then have their teachers, educators, student affairs people, fraternity folks implement it in a way that is fair and gives everyone notice. So this isn't just a legal issue, but it intersects so critically with these legal issues, because for far too long, when people did complain, there was no process. The process was too stilted. There was too much retaliation. There was retaliation, any amount of which is too much. And we weren't seeing people feel safe on their campuses. And to the extent that has changed, we embrace that change and would like to take, along with the student activists, a little bit of credit for that.
Yeah. I was going to say, someone had asked about what to do if you feel like your school's procedures aren't fair. As a brief selfish plug, there's a website called knowyour9.org. I suggest that you check it out. And also OCR, I think, really has done a remarkable job of stepping up its enforcement. Without commenting on any sort of individual case, without sort of suggesting that there's no way that a school's response to an individual complaint could ever be unfair to the accused, I want to just sort of suggest an analogy that we have been living in a house with tilted floors for a very, very long time, and we have set up our furniture so to adjust to that. The back of the chair is longer than the front of the chair, and now it's sort of starting to equalize, and everything's off balance a little bit. And there's a feeling that suddenly there must be a presumption for people who have been historically dismissed as liars, as hysterical, as unworthy of equal stature on our campuses. And it scares me that our vision of how we are equalizing this requires victims of gender violence to come forward and tell their stories on a national stage, to file complaints and lawsuits, and that is how we imagine that suddenly they are wielding some kind of remarkable power. I can promise you that's not true. I can promise you that that is a terrible burden to put on our students, that in order for them to have an opportunity to learn on campus, the first hit on their Google search for the rest of their lives needs to be that time they were raped freshman year. So I want to ask us sort of simultaneously to keep a long historical perspective of sort of the context of a couple years of progress, and also to both listen to students and find their leadership without putting the burden for justice solely on them. So thanks for having me.
I think we need to talk about alcohol in the context of Fatima's call for that conversation about healthy relationships and positive, as a society, we would benefit from a conversation about the way we use alcohol to lubricate sexual and social interactions. I am struck by the role of, Alexander, I think what you called rape exceptionalism earlier, in the way that we think about alcohol in this debate. So as a society, when we talk about alcohol-based harms, if you get in your car and kill someone, or if you get drunk and go around shooting up a weapon, somehow we tend to think about the role of alcohol for someone who perpetrates gender or sexual-based violence on someone as being different than those harms, and that concerns me. So I think we can actually have, as a society, a really important discussion about how we think about alcohol and our responsibility for the harms we cause when we're intoxicated. It's interesting, Judge Gertner, it may be a Harvard context. I'm thinking about whether I think I and the people I know worry more about now about kind of being sued by people who file complaints because we have not met their needs. And I actually don't think that's the case on my campus and for the other practitioners I know. We kind of assume that somebody's going to sue us no matter what. And I have to say that that is concerning from an economic standpoint. And so as a practitioner, the one thing that hasn't been part of this conversation I'd love to talk about is the economic impact for campuses of Title IX. But that's actually a kind of an enormously freeing place to be, because it lets us have, really it is, because you can have what I think is actually the right conversation, which is the lawsuit you want to defend, right? And the lawsuit you want to defend is, we did what we thought was the right thing and here's why. And I think that that's, what I see as kind of the positive aspect of the moment that we're in right now is we're being called to do the right thing, and we're being called to bring together a whole set of professional specialties to figure out what the right thing is. That's actually enormously exciting. I don't think we're there yet, and every day I feel like I go to work and think about, okay, it's a fail better day once again. But I do appreciate being in a moment where we can think about and center what that right thing for everybody involved might be.
Please join me in thanking our panelists.